Okay, sorry, but I had to pause it slightly whilst I sorted my tea out. So anyway, I could smell it burning. Anyway, getting back to what we're talking about. So yeah, every time the Supreme Court interprets this constitution, remember quite a lot of it is vague and wishy-washy, a bit like student essays. It is interpreting the constitution. It is kind of amending the constitution through interpretation. And the argument is there the right balance between politicians doing this and the judiciary who are unelected doing this? And I'm going to argue I think there is. Okay, I think politicians play quite a big role in this and they're elected by the people. I think that the judges who interpret the constitution, they have a right to do so and they're probably the best people to do so. So many changes to the constitution is done through judicial review. Okay, and it's only right that judges should interpret this constitution because A, they're legally trained, they are not partisan, or not supposed to be partisan, unlike politicians who've got vested interests in winning future elections. And when they are making these decisions, the judges don't just say, "Oh yeah, we're going to do this." They state the reasons why they've made that particular interpretation. And if any judge on the court disagrees, they give a counter reason as to why they disagree, which again enables these debates. And remember, the vagueness of the constitution, okay, has enabled this to take place. And it's enabled the institutions to grow and breathe. So things like the elastic clause and the commerce clause, for example, have enabled Congress to live and breathe. And the constitution and the way that it is set out has prevented kind of a radical change in many ways. It's allowed it to develop and grow. And the Supreme Court has, on a number of occasions, supported the elected politicians, these people elected by the people, when they've used the Commerce Clause or the Elastic Clause. So things like, the Affordable Care Act, otherwise known as Obamacare, the Supreme Court, in a case called Sebelius, the NFIB versus Sebelius, supported what the elected politicians had done. It was a 5-4 majority, but they said, yeah, that's fine under the Constitution. They had a few reservations, but generally speaking, it was fine. And this is only right. And politicians, remember, do have the ability, if they think the Supreme Court has interpreted the Constitution incorrectly, or they don't like their interpretation, they do have the ability to actually amend that Constitution to actually overturn what the judges have done. So if they think the judiciary become too powerful and they're making the wrong decisions, they can begin the process of amending the Constitution more formally to override those judges. So the last time this happened was 1971. The Supreme Court had a case called Oregon versus Mitchell, where they said the states, it's up to the states to determine the voting age, which a number of states have said it can't be less than 21. This was overturned by a constitutional amendment, which made it 18. So that decision of the Supreme Court was therefore null and void. So politicians are, and judges do have this balance. The Supreme Court do make informal amendments to this constitution, but if they're seen to overstep the mark, then the elected politicians can begin the process of amending the constitution more formally, which therefore negates, that's a posh word, the judiciary. Now, the counterpoint to this would be, actually, this isn't really true, is it? Okay, it's so difficult to amend the constitution. It's very rare that, it's cloud cuckoo land to say that politicians will, if they don't like a judicial decision, they'll just change the constitution. Like we said before, the last time this happened was 1971. That's before even I was born. That's 54 years ago. I'm making this in 2025, something like that. Okay, there's been lots of very controversial decisions made by the judiciary based on this constitution, which have upset liberals and have upset conservatives, yet there's been no formal change. The Supreme Court interpreted the constitution to say that abortion was legal, that the states had no right to ban abortions. This was back in 1973, Roe versus Wade. This really upset many conservatives. It pleased many liberals. The Supreme Court in 2022 reversed its decision, said actually we made a boo-boo. Actually it is up to the states to decide, not the national government, which led to abortion being banned in many states. So not only have they upset, now they've upset the other side, basically. So this has been very contradictory as well. How can you have a constitution which can be read in such two different ways. And no, politicians haven't been able to just amend the constitution one way or the other. You said the same about gay marriage, Oathell versus Hodges. There's a number of cases, and also the Supreme Court recently, because it's got a 6-3 Conservative majority, has been accused by many Liberals of interpreting that constitution to favour Donald Trump and the powers of the presidency. So Trump versus USA in 2024 basically said the president was immune from prosecution for actions taken whilst they are president. Okay? They've interpreted the constitution as that is what they mean. Conservatives liked it, Liberals hated it. The Supreme Court Justice Sonia Sotomayor, who's a Liberal, said we have created a king. Okay? Clearly not what the constitution was intended. Clearly not, for the previous paragraph, showing sufficient democracy. So the balance is wrong. Okay, the judges are far too powerful. These unelected judges and their interpretation of the Supreme Court. It's cloud cuckoo land to say, yeah, but actually politicians can overturn their decisions, because the last time was 1971. Actually, I think I've changed my mind on my argument as this has gone on, but anyway, I have to stick to my guns because I made the argument in the introduction. I would say this is a weak argument. The better view is actually it's got the balance right. You do need unelected judges being able to make these sorts of decisions. The constitution can be changed by elected politicians. And if they think that change has got sufficient support, then they need to go ahead and do it. So that's the arguments for and against. So is the constitutional amendment process suitable or sufficient or fit for purpose? They would be my three themes. Okay, they would be the points I would make. And notice how I've mentioned quite a range of amendments here. I've not just described one or two. I've mentioned flag burning. I've mentioned things about electoral college being changed. The rebate on guns I've mentioned. Equal Rights Amendment. Washington DC having statehood. I've mentioned 18-year-olds being out. There's a whole range of stuff I mentioned, which again is what you need to do. Okay, well that's been helpful and useful. And I'll see you for a future one in the not too distant future.